I am attorney Michael Brown of the law firm DVG Law Partner LLC. I represent individuals and businesses in legal disputes against large organizations. I practice in areas of contract rights, fraud victim rights, and employee rights. In this video, I'll discuss what are common attributes to good legal cases. What I should note first is that this is general information and it is not legal advice. If you want legal advice about a specific situation, please talk to an attorney. Most good legal cases have several factors, and what I'm going to discuss is those factors. The first factor in most good legal cases is the suffering of significant financial loss, either a financial loss suffered by an individual or by a class or group of individuals, or by an entity in the case of a business, or a group of entities. The significant issue, though, is whether there has been a substantial financial loss or the potential for a substantial financial loss. And the reason why I talk about financial loss is that the legal system is good at addressing issues of repaying money lost or paying for ordering the payment of money that can be quantified. But if an issue is not tangible to a legal authority, it is more difficult for that authority to fix what has gone wrong. In the case of an individual, there may be lost income as a result of your opponent's actions, or in the case of a business or a consumer, there could be a loss of money that has been paid to an opponent. But the key here is that if there is some tangible loss that is substantial or at least significant individually that's due to the act of an opposing party, then that is one attribute of a good potential legal claim or lawsuit. I should note that most strong legal claims will have other attributes of loss, such as a physical injury or an emotional distress type of injury, but those issues often correlate with financial loss. For example, if someone has a physical injury and a personal injury lawsuit, there are often medical bills that accompany or correlate with that injury, and so the financial issue is usually an issue of most legal claims and most types of harms that occur. There are certain exceptions to this general rule of having significant financial loss, and one example that comes to mind are certain legal claims have statutory penalties. For example, a federal wiretap law would have a statutory penalty according to the violations or the number of violations that occur. And so even if someone does not suffer a financial loss directly due to an act of illegal wiretapping, it's still possible that that person or company, whatever the case may be, may have a legal claim with significant value due to statutory penalties, which can at times multiply on basis of how many legal violations occurred or how many days or instances of legal violations occurred. So as a general rule, if someone or a group of entities have suffered significant financial loss, that's factor one for a potentially good legal claim. The second factor that is present in most good legal cases is a viable opponent. And by viable, I mean the opponent is able to pay for the damage that was done financially. Either they or their insurer is able to foot the bill, so to speak. And the reason why finance has become such a prominent topic of my discussion early on is because on your own part, you will have an investment of resources. You will certainly, if you have a legal action, have to invest your time and your work. And in the case that you have an attorney who's not on contingency, then you may be paying that attorney significant value towards legal fees. And so because of those investments, it's important to keep in mind, will you recover? Will you recover for your initial financial loss? Will you recover for investments that you make into a lawsuit? And if the opponent is clearly in the wrong, but they're unable at the end of the day to pay for money that was lost, or if they're unable to fix the damage that was done, for example, if they are bankrupt or defunct at the point of a legal decision, that's important to consider those types of issues right up front and whether it's a possibility. Because if it is a possibility or a likelihood, then it may be a case that's not worth pursuing. So the second factor, again, would be the viability of an opponent or their insurer to pay for or to fix the harm that was done. The third factor of a good legal case is the issue of liability, or in other words, is the opponent legally in the wrong, and is there proof to support that the opponent was legally in the wrong? For this factor, you should seek the help of an attorney, not necessarily to look into the issues or potential laws that you feel may have been violated by your situation, but more importantly, before you take any action based on an assumption you have from your own research, consider getting the feedback of an attorney who's experienced in the issue or issues for which you're dealing. The reason why I say that is because in my experience with talking with thousands of clients and potential clients, far more often than not, their own assessments of a legal claim are wrong. However, it's also common for potential clients, including smart and capable people in their everyday lives, it's also common for people to misdiagnose a legal claim, but to miss a legal claim that is a strong legal claim, and that did not surface on their radar when they were doing their own legal research from Google or from government websites and so on. So it's very important that you consult with an attorney at some point before you take any sorts of actions, whether it's filing a legal complaint with an agency or with a court, or before you contact your opponent and talk about your belief you have a potential legal claim or that you may get an attorney. Before you take any actions that are based upon an assumption of liability or legal claims that may apply, or the strength of those legal claims, it's good to talk to an attorney so you can get feedback from a legal actor, so to speak, who is familiar and has gone through, familiar with the potential claims and situations, and has gone through the drill, so to speak, and has an idea of how those claims usually work out. An attorney, among other things, could address all the potential legal claims that may apply to a factual scenario that you have, potential legal deadlines that may apply for those claims, criteria or elements of legal claims, and whether those criteria are met by the situation that you have and by the forms of proof you may have. And the attorney, of course, could evaluate the types of proof you may have. It's one thing to be aware of certain proof, for example, to be aware of what an opponent said to you over the phone, or what may exist in the opponent's email accounts and so on. But it's another factor whether you in hand have certain types of proof and particular documentation that supports a potential legal claim. The stronger the potential proof that you possess, the stronger and of course, if there's a strong legal claim available, then the stronger the potential that you have a good legal case. I hope this is of some help, at least in getting your arms around the big picture of what factors make for a good potential legal case. If you have any questions about a specific scenario that you would like to discuss with me or my law firm, certainly feel free to contact me. We have a contact button that's easy to find on my firm's website, which is www.dvglawpartner.com.